the decision of the Supreme Court, or even the Constitutional Court before, are to the effect that from the word go, the General Court Martial had no power, had no jurisdiction. So there was nothing to transfer. That's why I want you to contextualize the decision of the Supreme Court. Finally, my Lord, on the question you did ask me, when we say that you be pleased to order now, the word normally used by lawyers is ex tempore of judgment. Oh, actually, I'll come back to this. The word is, it is usually used to describe an oral judgment, including reasons for judgment, given at the time of the hearing. That is the context of we propose and implore you to find pleasure in ordering release now. But this particular case of Kageni versus Musiramo was cited with approval in Rose Wanjiku Njau, Rose Wanjiku Njau versus Nicholson Philip and two others. Miscellaneous criminal application number 387 of 2012 by the Supreme Court of Kenya. To sum up, my Lord, in one sentence, the affidavit of Mr. George Karemera, which attaches a letter purportedly by the principal judge, and now you can see the bad faith, exchange reference, particularly those of us who went to the Supreme Court, does not place a lawful justification. It only talks about the administrative measures. Yes, my Lord. Yes, my Lord. My Lord, in principle, the Honorable Principal Judge is communicating measures taken by the judiciary administratively to guide the process of moving these files away from the deceased court-martial. No, my Lord, the principal judge, the Honorable Principal Judge does not bullet those measures. I'm avoiding the bulleting because I'll be reading into his letter, but I can read it. I have received rights to the Ministry of Defense and Veteran Affairs and to the Director of Public Prosecutions. I have received the attached self-explanatory letter from the Honorable the Principal Judge, Justice, the Chief Justice, advising that files pending before the General Court Martial that were subject of judgment of the Supreme Court and in the captioned case be handed over to the Honorable Principal Judge for further management. Yes, yes. This therefore is to bring them to the Principal Judge. The next is, this is therefore to bring the advice to your attention for your appropriate coordinated actions. Yes. And it is a letter dated the 6th February 2025. My Lord, even the principal judge's letter does not talk about the persons in custody. So it is not telling them continue with the detention. In other words, there is no single order of a lawful authority to detain. And it is that order which would have been the justification to restrict somebody's freedom. But let me ask a question and answer it. Thank you, my Lord. That's so gracious. On whose orders and under whose authority are the applicants in detention? Number two, what is the criminal case number? The Supreme Court having said the prosecution ceases and with immediate effect by 31st. By fall of night 31st, the criminal case number for the General Court Martial ceased. The file could be there for investigation purposes. You and I could be, maybe not you, maybe I could be under investigation, my Lord. God forbid, you should not. We need you. So the question is, under what criminal case number? And detained until when? The last time we had a detention which is unlimited in duration was under the Public Safety Act. And that one collapsed with the coming into force of our constitutional regime. Nobody can be detained indefinitely where there is no pending charge. That one will be a recipe for chaos in our country that anybody would detain. With that, my Lord, I can only say that let nobody drag the judiciary into this detention controversy of, say, relying on the order, the letter of the principal judge, an administrative letter. Very unfortunately. My Lord, if we are going to construe this as authority, the letter of the PJ, the next thing they will request you for a letter or granting a warrant to detain. And this was not a judicial letter. It was an administrative guidance to those persons, if they are still interested, prosecuting. Anything beyond that, my Lord, is a persecution, and I would invite you to put a hold on it. I so pray, my Lord. My Lord, in a minute. My Lord, in 1 minute, Sam Mulindwa is my name. I'll just take you to Article 43 of the Constitution, my Lord, where you cannot detain anyone without trial. There is no ongoing trial, my Lord. Secondly, everything about that defunct General Court Martial was nullified. We cannot continue discussing putting something on nothing. And an administrative letter, whether by the Chief Justice or Principal Judge, cannot be such authority to take away this provision of the Constitution, my Lord. My Lord, Father, my colleagues have submitted about Article 123, my Lord. If you look at 123B, my Lord.
This letter is not by PJ, sorry. It is by What?
Actually, my Lord, to conclude on the letter.
Correction.
to correct my statement.
Our statement.
Our statement, when I look at this letter, it is by Chiriowa Chiwanuka, not the PJ.
Actually, I apologize because I got a soft copy. I've only seen this physical copy, my lord. I withdraw the reference to the PJ. It is the Attorney General. I only got a soft copy here.
My lord, to conclude, reading Article 123B, even the DPP, my lord,
When you say the letter is by
Chiriowa Chiwanuka.
you mean the honorable Attorney
Yes, my lord. I told you-
Honorable by designation.
Honorable, my lord, honorable by designation, but I knew that this court would take judicial notice of that, my lord. Finally, my lord, my reading of Article 123B actually precludes the DPP from even taking up any matters from the court-martial. It is very explicit. So most of the submission and the affidavit evidence that I've seen from the Attorney General is misconceived to the extent that it believes, the Attorney General believes someone can be in detention
On orders of
on orders of the Attorney General. My lord, I join issues with my colleagues. Probably the rest will come in rejoin. Obliged, my lord.
Then
There's been a lot of scoring this court, particularly when I mean, we love it when they express their mighty. You have to do it, not careless. Well, if I'm sure that that was that I would be very interested, then you will not have gained anything. Probably your client's matter would have gone before another judge and the whole man.
yeah.
So, that will be your audience. Fortunately, I don't get the line that if you insult me, then I will take you on court. They can insult me, they want to work with me. Don't expose me. That's about us. We think I hope the point is very edgy. Can't wait to see. I wish it would be edgy.
But he's not submitting, you can't see.
Yes, my lord.
It is not that they are given us. We are subject to them.
Can you take us back point by point where you oppose them?
My Lord, for record, again, I'm Johnson Nakwera, and I'm a senior state attorney. My Lord, the application for you and us all is for habeas corpus. And for habeas corpus, it has elements that you must prove for it to be granted. One is that a person or the applicant was arrested. The said applicant is in detention, whether by state or anyone else. And that the detention is illegal. It's not in contention that the applicants were arrested and are in detention. The only issue is whether their detention is legal or illegal. And it is our contention that their detention is lawful. Your Lordship, we are not here to review the Supreme Court decision.
Okay, let me go slow. I have to. So we are on the lawfulness.
Yes.
Point number one, bullet one is this court cannot review the Supreme Court decision.
Absolutely. And this is not the purpose of this application. The Land Honorable Chief Justice wrote about 200 pages, elaborate judgment, and it is self-explanatory. And it's straight law, my lord, that any person who feels the application or the judgment of court cannot be construed in the way they feel it should, they applied the same court that issued it for clarification. My lord, I'm not here to impose words, interpretations, because I'm not qualified to interpret the judgment of Supreme Court otherwise expressly given. Yes, and that's what I've said. I'm not here to interpret it otherwise as expressly given. Your Lordship, my boss, the Lord Mayor, who is part of this government, has elaborately read through the orders of Supreme Court. And if any case, he would be on my side defending government. He has elaborately read through the orders of court, dot by dot, word by word, and nowhere did the court say release. It only gave an order of transfer. Transfer all the files which are pending before the court martial to courts of civil courts. And from our affidavit, deposed by Mr. George Karemera, the Land Commissioner of Civil Litigation, he has ably indicated to you steps taken from 31st of January, when the judgment of Supreme Court was granted. I will not go through all the steps taken, but I can only take a brief that on 31st January, the Supreme Court indeed gave that judgment. Most importantly, the court ordered that all charges or ongoing criminal trials or pending trials before the court martial involving civilians must cease and be transferred to the ordinary courts of law with competent jurisdiction. To fulfill and implement the orders of court, on 3rd February, government commenced the implementation. We wrote to the Chief Justice, the Land Attorney General wrote to the Chief Justice requesting for a liaison contact on how transfer of files can be managed. On 4th February, the Chief Justice appointed the Principal Judge as the liaison contact and instructed him that all matters should be handled by himself.
So, if I now sit here trying to listen to this story, I superimpose myself on the role of the principal judge.
I'm coming to that, my lord. However, I didn't want it to push it into your mouth.
No, you can't.
But since you have already said it, my lord, I take it, and that is the position of the respondent. And on 6th February, my lord, the Attorney General forwarded the Chief Justice's instructions to Ministry of Defense and the Office of DPP. And on 13th February, that's when we received a decree from the Land Council for the applicants in the case of the respondent, in the case of Attorney General versus Kabazuguruka. And on 17th, the same was signed by both parties. My Lord, Article 28 refers to fair hearing and a speedy trial. Speedy trial and fair hearing is not one-sided. It is both parties. In this case, the applicants and the state. The state has taken action to implement the orders of court. The orders of court are clear to transfer the files. And it's not in contention that indeed the applicants had been charged at court-martial and they had been remanded and there was a warrant for their remand. If the Supreme Court wanted to cancel the remand warrant, it wouldn't have taken a paragraph after almost 200 pages to mention so. It only said transfer the files to ordinary courts. And that's what the state is doing. It would be contempt of court, the Supreme Court, for this court to order otherwise. Or order release all the accused in the court-martial. And for your information, my Lord, it's not the applicants alone who were before the court-martial. There are many. The fact that there is no order on court record, I have had my land senior colleague, Honorable Segona, trying to explain what is not in the judgment of the Supreme Court. I don't know whether we have different copies of the same judgment, but there is nowhere where the Chief Justice said otherwise, apart from transfer. And if he wanted so, he would have mentioned it. The fact that the Supreme Court did not say release, it was aware of what it was doing. And in that so, it validated all the orders that all the suspects are best going to be in prison. If it had deemed otherwise, a sentence of saying release, actually that word alone, release, would have been enough. But if there is any party that misconstrued the judgment of Supreme Court, the right forum is the Supreme Court. As an office of this court, Honorable, I need to guide that do not be misguided by my land colleagues from the other party. Most obliged, my lord. Most obliged. And I'm alive to the fact that you are a doctor-in-law. You will not be misled. So the aggrieved party in this circumstance, my lord, for the misinterpretation of the Supreme Court decision it would go back to the same court that issued the same order, what it meant by saying this. It is in the interest of the state and for the people of Uganda that justice is done on both fronts. The biggest issue.
What the lawyers said are saying, fine, you are doing something. For how long must this wait? And you want to address that?
Yes, my lord. I will not accuse the Supreme Court that it didn't give us a timeline. But however, from the reading of our evidence, the judgment was given on 31st January. Immediately, on Monday next week, which was 3rd, we acted, and the process is ongoing. We are not going, I cannot mention how many files are involved, but they are numerous. And the process of expediting the process is of course, and that's why the principal judge was allocated this responsibility. It would be premature and unlawful.
There is an allegation of slow speed on your part. It is because of the volume of work you have.
Absolutely. Absolutely. And it would be injustice, my lord, to say that slow speed. For example, this application was served on us last evening, around 9 p.m. There is an affidavit on record. I didn't sleep. My team did not sleep. That Attorney General did not sleep. I was on phone up to midnight to respond, to ensure that justice is served on both fronts. My lord, in conclusion on my part, this application is misconceived because the applicants are aware that they are in detention illegally, and the state is not denying where they are. And at any time you want to look at him, you can even visit him, anyone can visit him. And if anyone can want him to be produced in court, can be produced in court. But ordering his release would be in contempt of the Supreme Court decision. I so submit, my lord.
My lord, just in 1 minute. My lord, I would like to associate myself. My name is Jackie Amsugut. I would like to associate myself with my colleagues' submissions, but I just want to emphasize that as has been rightly submitted by my former teacher, my lord, Counsel Kalibala, that yes, one of the orders, one of the conditions has been fulfilled, and that is the production of the applicant. Now, the other issue would be the lawfulness, or whether or not he is in illegal or legal detention. My lord, I want to emphasize that we should not read into the judgment of the Supreme Court what it did not provide. This was a decision of the Supreme Court, not sitting as an ordinary court, but as a constitutional court. And my lord, as the highest court of the land. Now, my lord, as officers of the court, we need to respect court orders. And for the applicants to come to this court and read into the court's decision that the warrants that were given by the court-martial have been invalidated is a very serious misconception, my lord. Our submission, my Lord, is that the applicants are in lawful custody. And why am I saying that? I would like to make reliance on an authority of R versus Governor of Brixton Prison.
Instead of going there, why don't you discuss in India? Because the former teacher said in India, where he was
in fact, my Lord, I am trying to justify that we are holding him or holding the applicants in a lawful way, or we are having them in lawful custody, supporting what my teacher has said, that we should justify that we are holding him in lawful custody. And in this decision, my Lord, it's called R versus Governor